Imagine a landscape where states and local communities, well, they aren't just following federal immigration rules, they're actively recalibrating national policy itself.
Hmm. Recalibrating, that's a good way to put it.
Yeah, they're influencing who gets legal status, who faces deportation, and they're doing it through seemingly small but incredibly impactful local decisions.
Right, this whole dynamic, it's often called immigration status federalism.
Exactly. And it's like this quiet revolution reshaping America's borders, but from within.
It really is. And we're talking about very concrete things, aren't we?
Totally tangible actions, like 8 states that have subtly snipped just one day off maximum misdemeanor sentences, dropped them from 365 to 364 days.
Which sounds tiny.
It sounds tiny, but why? It's to prevent non-citizens from automatically triggering federal deportation rules.
Ah, that 1-year sentence threshold.
Precisely. Or think about how some states define child more broadly for special immigrant juvenile status, while others, like Nebraska, actually tighten it up.
Yeah, Nebraska requiring abuse from both parents, not just one, which is stricter than the federal standard.
Right. So it's not just theory. It's this complex, sometimes contradictory web of rules that varies state by state.
And inevitably, when federal authorities perceive these local actions as, say, undermining national security or their control over immigration.
Then you get tension. The stage is set for a pretty dramatic showdown.
Absolutely.
So from local courthouses right up to the highest offices in Washington, the battle for America's borders, it's being fought on some pretty unexpected fronts. It really challenges who holds the reins of power.
Mm-hmm.
Today, we're taking a deep dive into these evolving dynamics of U.S. immigration policy. We'll look at how state and local governments wield this surprising influence.
We'll also unpack that very charged debate around the criminalization of immigration.
And explore the federal government's decisive and often controversial responses to what it sees as critical national challenges.
Right. We're aiming to uncover specific examples where local laws really affect federal outcomes.
And how the executive branch pushes back, to secure the border and maintain order.
So what's really central to this whole discussion, this deep dive, is understanding what some call a third category of immigration federalism.
Okay, a third category?
Yeah, because most people think of immigration federalism in, like, 2 ways. Either states enforcing federal laws, or maybe states providing benefits to immigrants.
Right, that makes sense.
But this is different. Here, states are deeply involved in determining who even receives immigration status in the first place.
Wow. Okay. That's a significant shift.
It is. And it's rooted in Congress actually delegating numerous selection functions to the states. They recognize state expertise in criminal law, family law, employment law.
So Congress intended this to some extent?
Well, they delegated the functions. Whether they anticipated all the ways states would use that authority is another question. But it means local policy effectively becomes a filter for federal immigration status.
That's a crucial distinction. So states aren't passive. They're actively shaping who gets to stay. That sounds like, well, immense leverage.
It is.
How does this play out day to day, especially with things like humanitarian visas?
Well, it's a powerful mechanism because states can use their existing legal systems, their social support systems. Take UNT visas, for example.
Okay, those are for victims of crime and trafficking, right?
Exactly.
Yeah.
Victims of certain crimes like domestic violence or assault or trafficking victims who cooperate with law enforcement. Now, to get these visas, they often need a certification from a state or local authority.
Like a police department or a prosecutor?
Yeah, or a judge. Someone confirming their cooperation. And we've seen 24 states plus the U.S. Virgin Islands actually bolster or expand these certification processes.
Making it easier to get that certification.
In many ways, yes. Many jurisdictions now mandate faster response times, anywhere from a quick 15 days up to 120 days, which is critical if your life is kind of in limbo.
Absolutely. Waiting months isn't really an option sometimes.
Right. In 11 states, even fast-track cases for applicants who are already in removal proceedings or maybe nearing an age-out deadline where they might lose eligibility if they turn 21.
So states are really leaning in to help victims access these protections. What's the federal reaction? Do they generally accept these state certifications?
It's a fascinating dynamic because despite all this state influence, federal approval rates for U visas have been consistently high, averaging 80% from 2009 to 2023.
80%? That's quite high.
Yeah, and it never dropped below 70% in any single year during that period.
So what does that tell us?
Well, this strong, consistent approval rate suggests a kind of pragmatic federal acceptance of state findings. Maybe less about a grand philosophical agreement.
And more about practicality.
Exactly. Acknowledging the state's on-the-ground expertise and just the practicalities of processing these complex cases.
Yeah.
Federal adjudicators, the folks at USCIS, they seem to largely trust these local determinations.
That's remarkable consistency. And it highlights, a surprising level of federal deference there. But it's not just UNT visas, is it? Special Immigrant Juvenile Status, SIJS, that also seems to rely heavily on state courts?
Oh, absolutely. SIJS is another critical pathway. It offers a route to naturalization for immigrant kids who can't safely reunify with a parent because of abuse, neglect, or abandonment.
And the state courts are key.
The entire process hinges on state court findings. The court has to declare the child dependent or place them in custody and, crucially, determine that reunification with one or both parents just isn't viable because of these issues.
And this is where states can inject their own policy preferences again.
Precisely. Sometimes expanding eligibility, sometimes tightening it.
Like defining child differently.
Yeah, some states define child expansively to include youth right up to 21, the federal maximum. That broadens who can apply. Minnesota, interestingly, defines abandonment broadly to even include a parent's death.
Huh. Opening it up in unique ways.
But then you have the other side. Like we mentioned, Nebraska's Supreme Court requiring abuse by both parents. That's much stricter than the federal one or both standard.
So quite a bit of variation, yet what are the approval rates like for SAJS federally?
Still very high, average 93% from 2010 to 2023.
93%? Wow.
Yeah, so again, it indicates that the federal government, primarily USCIS, and the immigration courts under EOIR, generally accepts these state court findings despite the variations in state law.
Okay, here's where it gets really interesting to me, and frankly, quite clever strategically. States altering their criminal laws specifically with federal immigration consequences in mind. This 364-day rule you mentioned, that's a prime example. 8 states reducing maximum misdemeanor sentences from 365 to 364 days.
That single day.
That single day. It's clearly a strategic move. It effectively insulates non-citizens with those convictions from automatic deportation because that federal trigger is set at sentences of 1 year or longer.
It's a powerful example of states finding these pressure points within the federal system. Some states even decriminalized marijuana possession and explicitly cited immigration consequences as part of their reasoning.
So they're not hiding the ball on why they're doing it.
Not always, no. Yeah. And what's fascinating is the tension this creates in the federal courts.
How so?
Well, some federal courts look at these state actions, especially the 364-day rule, and see them as improper attempts to circumvent federal law. They argue Congress has the exclusive prerogative over removal.
Basically saying states are overstepping.
Right. But other federal courts defer to state expertise in criminal law and domestic relations. They argue states have a legitimate right to define their own crimes and penalties.
So you get different rulings depending on the court.
Exactly. It highlights a deep doctrinal split, a fundamental disagreement among courts on how to interpret the law. It's like a battle of the branches playing out.
And it's not just state legislatures. Local DAs, prosecutors, they're involved too, right? Through prosecutorial discretion.
Yes, that's another key layer. District attorneys in places like Kings County, Brooklyn in New York, or Alameda County in California have implemented policies to actively consider adverse immigration consequences during plea negotiations.
Meaning they might offer a different plea deal?
Potentially, yes. Offering a plea to a lesser charge that doesn't trigger a federal deportation, trying to avoid disproportionate collateral consequences for non-citizen descendants. California even has a law, Penal Code 2016.3b, that mandates this consideration.
Mandates it. Wow.
Yes, requires defense lawyers to advise on immigration consequences and the court to consider them. So local DAs are making decisions daily that could literally determine if someone faces deportation.
This really brings us to that critical point you raised earlier, the whole criminalization of immigration debate. The narrative around immigration has, at times, been incredibly charged. We've heard rhetoric characterizing immigrants in very negative ways.
Unfortunately, yes. Terms like rapists, murderers, and animals have been used.
But the data tells a different story.
Consistently, yes. Data indicates that immigrants, including those who are undocumented, actually make up a small percentage of criminals. Statistically, they're less likely to commit crimes than U.S.-born individuals.
So what does criminalization mean in this context, then?
Often, it involves redefining offenses. Things that were once minor, maybe traffic violations or administrative infractions, get redefined or prosecuted in ways that make them more serious for immigration purposes, especially using the aggravated felony label.
An aggravated felony in immigration law isn't always what we think of as a felony in criminal court, right?
Not at all. It can include surprisingly minor offenses, maybe a small theft, simple battery. But for a non-citizen, that label is devastating. It often means mandatory detention, mandatory deportation, and it strips away most legal avenues for relief.
So a minor local offense spirals very quickly into a major federal issue, potentially leading to deportation, maybe before the person even understands the full consequences.
That's often the reality, yes.
Okay, so this shifting dynamic locally, it obviously puts immense pressure on the federal side, enforcement, courts, the whole system. Let's pivot to that. The sheer scale of the challenges at the border and for the agencies involved.
It's enormous. Just look at Border Patrol numbers, part of Customs and Border Protection.
Right.
The number of agents nearly doubled, from about 8,500 in 2000 to over 16,000 by 2018.
Huge increase.
Huge. Yet even then, the agency really struggled to fill another 5,000 positions requested by the president. They only managed to add about 118 new agents in 2018.
So hiring is a challenge too.
Definitely. And we've even seen military troops deployed to the border, which signals the level of perceived pressure. But it's not just about total numbers, it's about where those agents are.
Deployment.
Data from 2017 showed only about 61% of agents assigned to the southern border were actually patrolling it, which points to internal resource allocation challenges.
So more agents doesn't automatically mean more presence right on the line. Meanwhile, ICE, Immigration and Customs Enforcement, they handle interior enforcement. How active are they?
Incredibly active. In 2018 alone, ICE made over 158,000 administrative arrests. That was an 11% increase from 2017.
And these are administrative arrests.
Yes, crucial distinction. They're arrests for civil violations of immigration law, not necessarily criminal offenses, although arrests often happen alongside criminal proceedings. And programs like Secure Communities amplify this.
How does Secure Communities work again?
It was reinstated by the president.
Yeah.
It means fingerprints taken during local arrests get automatically shared with federal immigration authorities.
Right.
So any local police interaction could potentially become a federal immigration trigger if the person is identified as a non-citizen.
Okay, so massive enforcement efforts, but then the cases hit the immigration courts and they're just swamped.
Completely overwhelmed, caught in a staggering backlog. As of January 2019, think about this, over 352,000 affirmative asylum cases pending, over 821,000 total immigration cases pending.
Just staggering numbers. The system is clearly straining.
Bursting at the seams. And what adds another layer of complexity, maybe even concern, is the structure. Immigration judges aren't part of the independent judiciary like federal judges.
Right, they work for the Department of Justice.
Exactly. They're DOJ employees reporting to the U.S. Attorney General, which inevitably raises questions about impartiality, judicial independence, potential conflicts of interest.
Especially when policy shifts come down from the top.
Absolutely. And we've seen the impact. Declining asylum approvals, for instance. USCIS approvals for affirmative asylum dropped from 43% in 2016 down to 30% in 2018.
That's a significant drop.
It is. And EO-WIRE, the courts themselves, saw approvals fall from 43% to 33% in that same period. This isn't just statistics, it's thousands of people being denied protection.
And the Attorney General has intervened directly, too.
Yes. The AG issued rulings limiting asylum grounds, saying claims based on domestic abuse or gang violence are generally not sufficient grounds anymore, and also directed judges to stop using administrative closure.
What's administrative closure?
It's basically a tool judges use to pause a case indefinitely, take it off their active docket, maybe allow someone to pursue another form of relief. Removing that tool forced judges to keep more cases active, arguably worsening the backlog.
And on top of all this, immigrants facing deportation aren't guaranteed a lawyer like in criminal court?
Correct. No guaranteed right to counsel. And a huge study looking at 1.2 million cases found a stark difference. Detained immigrants. Only 14% had lawyers.
Only 14%.
Compared to 63% for non-detained immigrants. That lack of representation has a massive impact on outcomes, navigating the complex system, everything.
It's hard to imagine facing that system alone. So with detention numbers rising, where are people being held? You mentioned private facilities earlier.
Yeah, that's a major factor. While private prisons hold less than 10% of the overall U.S. incarcerated population, a striking 73% of immigration detainees were in private facilities back in 2017.
73%, that's huge.
It is. And the growth rate of people in private prisons was 5 times faster than the total prison population growth between 2000 and 2016.
Why the reliance on private facilities for immigration detention?
It largely reflects a strategy to quickly scale up capacity to manage the increasing numbers being detained, especially under policies aiming for more enforcement. But it comes with ongoing debates about cost, oversight, conditions, and accountability.
Okay, so we have states finding ways to influence status, a federal system under immense pressure. How does the federal government, particularly the executive branch, try to assert control? One tool is emergency powers, right?
Yes, executive emergency powers. The National Emergencies Act, the NEA from 1976, was actually meant to constrain executive power.
But it has loopholes.
Big ones. It doesn't clearly define what an emergency is, and declared emergencies can just persist for years, decades even. The Iranian hostage crisis emergency declared in 1979, technically still active.
Still active, wow.
Yeah. And this lack of clarity allows for broad interpretation. Recently, a president invoked a specific section, 2808 of the NEA, to declare a national emergency at the southern border.
For the border wall fund.
Exactly. To redirect military construction funds for the wall. This was really an unprecedented use of that specific provision, usually applied to overseas military needs. It was a major assertion of executive power, bypassing Congress on a highly contentious issue.
A clear message of federal control. But besides big declarations, there were quieter methods too. This invisible border wall.
Right. That term refers to procedural changes that make immigration processes much harder without actually changing the laws on the books.
Like what kind of changes?
Things like making application forms much longer, requiring more in-person interviews, even for green cards, and this really strict rejection policy for applications with any blank fields.
Even if the answer was not applicable.
Even then, you had to write NA. Leaving it blank meant automatic rejection. These bureaucratic hurdles added months, sometimes longer, to processing times, created huge obstacles.
But you mentioned earlier that even with these hurdles, approval rates for things like U visas and SIJS remained high.
Largely, yes. Which suggests it's hard, even with executive directives, to just outright reject state-level factual findings, especially involving victims or kids. Courts also pushed back sometimes, striking down policies that tried to second-guess state courts too aggressively.
So a constant push and pull.
Definitely. The judiciary often acts as a check.
Okay, let's look at some specific big directives from one administration around August 2019. These really show that federal push for control. First, the border wall itself.
Right. The promise was 500 miles of new fencing by 2020, but a lot of the actual construction involved replacing or upgrading existing barriers.
Not all new wall.
Correct. And orders were issued to speed it up, which included seizing private land, potentially ignoring environmental rules. It showed a real determination to fulfill that key campaign promise, whatever the cost.
Then there was the public charge rule. That caused a lot of concern.
It did. This rule allowed federal officials to deny green cards and visas if they deemed an immigrant likely to use public benefits in the future, things like Medicaid, food stamps, housing assistance.
The idea being immigrants should be self-sufficient.
That was the stated rationale. To ensure self-sufficiency, reduce strain on welfare. But it significantly broadened who could be considered a public charge, making many families afraid to access aid they were legally entitled to.
And safe third country agreements, what was the goal there?
The idea was to prevent asylum seekers from reaching the U.S. border in the first place. The U.S. signed one with Guatemala in July 2019.
Requiring asylum seekers passing through Guatemala to apply there first?
Exactly. Before they could even ask for asylum in the U.S. Similar deals were planned with Honduras, El Salvador, Panama. But critics immediately questioned whether countries like Guatemala, with high violence and poverty, could truly be considered safe for vulnerable people.
A lot of controversy around that.
Huge controversy. And then there was the expansion of expedited removal.
Right, faster deportations.
Much faster, and for more people. This policy allowed federal agents to deport someone without a hearing before an immigration judge if they couldn't prove they'd been physically present in the U.S. continuously for the past 2 years.
2 years? That's a broad reach.
It significantly broadened the scope compared to previous limits, expanding the government's power to deport quickly and with less judicial review.
And finally, the federal response to local sanctuary policies. How did that play out?
Well, over 600 counties and cities have policies limiting cooperation with federal immigration authorities. Maybe not holding people in jail just for ICE, for example.
And the federal government pushed back hard.
Very hard. The president threatened to cut federal funding to these cities, even suggested transporting detained immigrants to sanctuary jurisdictions as a kind of political tactic.
And then the situation in Washington, D.C.
Yeah, that was striking. Amid concerns about local crime statistics and governance in D.C., the president threatened a full federal takeover of the Capitol,
A federal takeover.
claiming D.C. was safe again only after National Guard and police actions. And a top House Republican backed the idea, framing it as the federal government rightly intervening where local control was seen as failing. A very direct assertion of federal authority over local affairs.
So putting it all together, these state-level maneuvers, changing federal outcomes, the immense pressures on the federal system, and then these robust, sometimes controversial federal responses. It's a complex picture.
It really is. What's truly illuminating is how all these actions, the quiet state legal changes, the loud executive orders, the direct interventions, they all converge on this fundamental question of authority. Who's in charge?
It's not simple, not one-sided.
Not at all. It's a complex, multi-layered struggle. States, localities, the federal branches, all vying for influence, creating this constantly shifting, often unpredictable immigration landscape.
So, what does this all mean for you listening right now? Whether it's through those clever state-level legal moves trying to protect non-citizens, or powerful federal actions aiming to secure the border, or even direct interventions in how cities are run. The fundamental question really remains. Who ultimately gets to define what it means to belong in America? And what's the true cost of this ongoing, ever-evolving struggle for control?